March 5th.
Set date, everyone.
Yes. I was reading your mind.
Not too hard. Not too hard to do. I guess we'll get started when courtroom 2 comes online.
Okay.
Good afternoon, courtroom 2. I hope you all are well this afternoon.
Come on.
Position number 1, we have Ms. Dior.
Okay.
Well, we'll hold off on Ms. Dior. She went to the restroom. We'll go with position number 2, Mr. Freeman.
Okay. Good afternoon, Mr. Freeman. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? I'm sorry, was that a yes, sir?
Yes, sir.
Okay, thank you, Mr. Freeman. You've been charged in case 24 CR 000823 with simple battery family violence. Afternoon, Mr. Howard. Is there a history?
Second arrest. You have a disorderly conduct.
Afternoon, Mr.
We
Go
can't.
ahead.
We can't hear Mr. Howard.
I can't even.
Mr. Howard?
Second arrest, disorderly conduct, no law.
Okay, thank you.
Good afternoon, Your Honor. Brief facts of the case is that on February 18, 2024, the officer was dispatched to 1 moment, I think it's 2011, Adamsville Drive, Southwest, Atlanta, Georgia 30331 in reference to a domestic fight in progress call. The radio remarks said that the caller advised that her baby's father punched her in the head. The officer spoke with the victim and she said the defendant they got into an argument earlier that day while she was over her taking a shower. The argument was over her refusing to accept a Valentine's Day gift from the defendant's mother. She continued to refuse. At one point, she left the residence with her child in hand, and the defendant continued to insist that she take the gift, at which point she put it on the counter. She then turned around and tried to leave again, and the defendant started punching her in the back of her head. The defendant himself admitted to pushing the victim in the back. Our office has been able to get in contact with the victim in this case. She states that they are in a relationship. However, they share one child. She stated that the incident location is the defendant's residence. She confirmed the events in the warrant. She states that this is not the first time that the defendant has been violent towards her. And this is not the first time the police have been called, but this is the first time he's been arrested. The victim states that she is not in fear of the defendant, but she is unsure if the defendant will be violent to her if they were alone again together. She states that she would be okay with contact so long as someone else is present. I do believe that she's on the Zoom call. Your Honor, the recommendation from the state is a signature bond through the pretrial services, no alcohol, drugs, or weapons, for there to be no further contact, for there to be the third-party transfer of the child as a means of contact, and for him to complete a anger awareness course. And if we could sound for Ms. Wilburn in accordance with Marcy's law, that'd be greatly appreciated.
What's Ms. Wilburn's first name?
It's Brianna, Brianna.
If Ms. Brianna Wilburn is on the line and wishes to address the court, now is your opportunity to do so. You, of course, don't have to, but if you would like to address the court, I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in. Okay, if she's here, it does not appear that she wishes to address the court. Mr. Cook?
Yes, Your Honor, we have no problems with no further contact. We certainly would like the third party accommodation for the visitation of the child. It's our understanding, that the alleged victim does not, and my client disputes the allegations of the warrant, but the alleged victim does not live at the Adamsville Drive address, so there shouldn't be any issue about stay away. My client should be able to bond down and go home, and he doesn't want any further contact. So we're good on all the no contacts and the third party transfer, and as long as he can go back home, because I don't believe she's a resident there in any way.
Yes, Your Honor, the state is not seeking a stay away from the location.
Okay, it'll be a $2,000 signature bond through pre-trial, level 1, 1-day anger awareness, no further contact with Brianna Wilburn, third-party transfer of any minor children for visitation, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Freeman. You're welcome.
Next, we have position number 1, your Electra.
Was that anger awareness?
Yes.
Okay.
Good afternoon, Mr. Yor. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are completing by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Yor, you've been charged in case 24 CR 000822 with battery family violence. Is there a history, Mr. Howard?
First arrest, jail was the recommendation.
Okay, thank you. Mr. Pierre Thomas?
Yeah, the brief facts of the case is the defendant and her daughter, the victim, were in a physical altercation inside of their place of residence, which is 2050 Cheshire Bridge Road, Northeast Atlanta, Georgia, in Fulton County, Georgia. The altercation started from a verbal dispute, which eventually led to a physical dispute between the two of them. The victim suffered multiple cuts and scratches to her face. The victim provided a partial video of the physical altercation. The victim also advised that the defendant threatened her by stating that she would beat her ass, quote unquote. Our office has been able to get in contact with the victim. She states that she confirms she is the daughter of the defendant. She states that they live together at the incident location. She confirmed the events in the warrant. She states that this is not the first time the defendant has been violent towards her, and this is not the first time the police have been called. But this is the first time, however, that the defendant has been arrested. The victim states that she does not feel safe around the defendant and does not wish to have contact with her. She states that she does not want the defendant to return to the resident and that she will need a one-time law enforcement escort to retrieve her belongings. I do believe that she is on the call. Her name is Kelsia, K-E-L-S-E-A, Rispres, R-I-S-P-R-E-S-S. The recommendation from the state, Your Honor, is a signature bond through the pretrial services, no alcohol, drugs, or weapons, a stay away from the incident location, no contact with the victim, the completion of an anger awareness course. And if we could sign for the victim in accordance with Marcy's law, that'd be greatly appreciated.
If Ms. Kelsia Rispes is on the line and wishes to address the court, now is your opportunity to do so. Of course, you don't have to, but if you would like to address the court, you need to unmute yourself, activate your camera, and I'll have to swear you in. Does not appear that she wishes to address the court. Mr. Cook?
Your Honor, my client disputes the allegations as stated in the warrant. Our position is that the alleged victim is actually the aggressor here. We seem to see this all the time. My client has lived in the Metro Atlanta area about 4 months. That's because she is at this point in a demobilized status with Homeland Security, for whom she has worked for 2 years. She has a bachelor's degree. She has no problem staying away from the victim. She wants that, but here again, we run into this problem all the time. She's on the list. I understand the issues about needing to evict, and no, I know the alleged victim is not on the lease. My client is on the lease and does most of the lease rent paying and not returning to the residence, her residence. It's going to cause some difficulty.
And I just point out that the victim did state that she's in fear.
Okay. Well, they obviously can't be around one another. So it will be a $2,000 signature bond through the jail. No further contact with Ms. Kelsia Repress. I understand your position, Mr. Cook, but if they both live there, regardless of who's on the lease, one of them will necessarily not be in that residence. So in this instance, it will be Ms. Dior. So she can't return to the 250 Cheshire Bridge road address. She can go back on one occasion with law enforcement to retrieve any belongings that she might have there, and no drugs, alcohol, or weapons while out on bond. Good luck to you, ma'am.
That's not relevant. That's not she. We're not on duty.
Next, we have position number 5, Alexis King. That's it.
That's okay to jail.
Yes, good afternoon, Ms. King. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. King, you've been charged in case 24 CR 0000826 with battery family violence. Is there a history, Mr. Howard?
Second arrest, 2012 suspended license, no low. This was level 1.
Good afternoon, Mr. Graham.
Good afternoon, Your Honor. This event took place on September 3rd of 2003. Law enforcement responded to a dispute call at 2249 Perry Boulevard in Atlanta. Upon arrival, they met with Fernando Cluster, who advised he was assaulted by his son's mother, Alexis King. Ms. King arrived at that location, threw some clothes on the hood of his car.
Hold on, Mr. Graham. Did we lose courtroom 2? Okay, there they are. I'm sorry. Go ahead.
Oh, no worries. Ms. King arrived at that location. She threw some clothes on the hood of Mr. Cluster's car before yelling profanities and launching at him, ripping his chain from his neck, causing some scratches. Our office has been in contact with Mr. Cluster. He advised that the two were in a relationship. They did not live together. They share one child. He confirmed the events in the warrant, says that they've had multiple domestic violence incidents in the past. They have an open case where he is the defendant and she was the victim. There was a no contact order, and within that bond recommendation, Mr. Cluster wishes not to press charges. He's okay with having contact with her. According to the victim statements that they've had previous issues and there's currently a no further contact, the state is still going to request a no further contact with Fernando Cluster. Signature bond through pretrial services, 1-day anger awareness, stay away from 2249 Perry Boulevard, no alcohol, drugs, or weapons.
Yes, good afternoon, counsel.
Good afternoon, Your Honor. Kenneth Mitchell for Ms. King. Your Honor, again, like Mr. Graham stated, Ms. King was under the impression that she was the victim, and now it seems like out of retaliation, Mr. Cluster filed press charges, apparently. But Ms. King would like to request a signature bond and no violent contact with Mr. Cluster. They do have a child together, but we would just ask for no violent contact with Mr. Cluster.
Okay, it appears that there's already a no contact provision in place. If I heard right earlier, on behalf of Mr. Cluster, so they should not have any contact because of the previous case. But in this case, it'll be a $2,000 signature bond through the jail. No further contact with Mr. Cluster. third-party transfer of the minor child for visitation and no drugs, alcohol, or weapons while out on bond. They'll have to find a third-party intermediary for visitation of the child.
Thank
Okay.
you. How can we receive an order?
Well, the orders will be prepared after court today, and Ms. Bridgewater, can you get Mr. Mitchell a copy of the order?
If he will put his information in the chat, I would be happy to.
Okay, thank you.
All right.
So, all right. Good luck to you, Ms. King.
Next, we have position number 3, Hardy Shakita. Yeah.
Good afternoon, Ms. Hardy. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Ms. Hardy, you've been charged in case 24 CR 0000824 with simple battery. Is there a history, Mr. Howard?
Second arrest, 2001 shoplifting. Jail was a recommendation.
Your Honor, brief facts of the case is that it appears that on November 17th, 2003, I believe that the victim was dining at a restaurant located at 2346 Cascade Road in Atlanta, Georgia. At which point the ex-fiance of her, I'm sorry, the ex-wife of her ex-fiance and the son entered said location and began to assault the victim, in this case, the victim being Tammy Sloan. Our office has been able to get in contact with the victim. The victim stated that exact statement. She states that she only met the defendant a couple of times and did not really know what the defendant looked like. She stated that when the defendant and her son walked into the restaurant, she did not know who they were at first. She stated that the defendant and the son came up to her and attacked her. She stated that while they were attacking her, they were accusing her and her daughter of sending harassing text messages to the defendant and her daughter. The victim stated that she was trying to explain to the defendant that her and her son that she and her daughter have also been receiving threatening text messages and from an unknown person, and that they would not listen and just kept attacking her, I guess. The victim stated that she is in fear for her safety and does not wish to have contact with the victim. And she stated that the defendant knows where she lives and she would like for the defendant to stay away from her residence, which is 1670 South Gordon Street, Southwest Atlanta, Georgia, 30310. I will put that information in the chat for the order, if so ordered. And the state's recommendation or the state's request would be a signature bond through the pretrial services, no alcohol, drugs, or weapons, a stay away. I would say both from the restaurant, which is the original incident location, and the residence, a no contact with the victim in this case, and the completion of an anger awareness course. And if we could sound for Ms. Sloan in accordance with Marcy's law, that'd be greatly appreciated.
Ms. Tammy Sloan is on the line and wishes to address the court. Now is your opportunity to do so. You, of course, do not have to address the court, but if you would like to, you'll have to unmute yourself, activate your camera for me, and I'll have to swear you in. Yes, ma'am. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court?
I just wanted to let the court know and Ms. Hardy know that we've been getting the same harassing text, and that's what I was trying to explain to her that day. I mean, I've got my daughter, it's my daughter who's actually receiving them. And she got one just as recent as 3 days ago, threatening us about coming to court.
Okay. Thank you for being here this afternoon, Ms. Sloan. We appreciate it. Mr. Cook?
Yes, sir. My client is 45 years old. She works as a medical assistant. We would have no problem with the stay away. She doesn't want any further contact. Ms. Sloan. Again, we would dispute the allegations in the warrant and the affidavit. I don't think we would hold that there's no necessity for an anger awareness course, and beyond that, we'd certainly like a signature only bond through jail if the court deems that appropriate.
Okay. Ms. Sloan, are you still with me?
Yes,
What's your daughter's name?
Raven, Raven, Sloan, Sloan.
Okay, thank you, ma'am. I appreciate it. It will be a $2,000 signature bond through pretrial level 1 day anger awareness, no further contact with either Tammy or Raven Sloan. Stay away from the Sloan's residence, which I understand is on Gordon Street, South Gordon Street. Also stay away from the restaurant where the incident allegedly occurred. No drugs, alcohol, weapons while out on bond. Since I have you here, Ms. Hardy, let me explain to you what no contact means. No contact means no contact whatsoever. Obviously, no personal contact, but no phone contact, no email contact, no social media contact, no internet contact. There would be no contact whatsoever. If there is contact, then this bond is subject to being withdrawn. All right. Good luck to you, Ms. Hardy. You also, Ms. Sloan.
Next, we have position number 7, I believe.
Myself?
Yes. These are right.
I'm sorry, who is it?
Yes, good afternoon, Ms. Mizell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 24 CR 000828 with battery family violence. Is there a history, Mr. Howard?
Second arrest, 2018 battery DV, first offender. It was jail was a recommendation.
Your Honor, the state is quite confused about how this even showed up on the calendar. I don't know if this is a reset or what, but the state will be seeking to, if forced to file charges today, the state will be seeking to add additional charges to the accusation. It was our attempt to have this heard in felony first appearance. If I could give you, straightforward facts of the case in this matter, one moment.
And who's representing Ms. Mizell?
I am, Your Honor. Good afternoon.
Good afternoon, Ms. McLeod.
One moment, the computer is running just a little slowly. I've pulled it up. Your Honor, the allegation in the warrant itself, although it is a battery family violence allegation, or the warrant itself states that the accused battered Keisha Thompson by grabbing her hair, pulling out her braids, and she scratched her in the face, as well as also pointed a handgun at her and stated while in front of her 3 juvenile children or 3 kids, saying that she would shoot her in front of the kids. The kids themselves also confirmed that the defendant had a gun and did attack their mom. And so I'm confused about how it made it to the calendar today. But if the state must make a recommendation I'd like to point out that we'd be seeking to add at least 3 counts of cruelty to children in the third. And I would be seeking a $10,000 surety bond, no alcohol, drugs, or weapons, a stay away from the incident location and no further contact with the victim in this case, and the completion of an anger awareness course.
Okay, so it was accused as a battery family violence, Mr. Pierre Thomas?
No, it's her sister who's the alleged victim, Your Honor.
Right, no, I'm, all I have in front of me right now is, as an accused case, is my understanding is a battery family violence. Is that
Yeah,
correct?
the
Mr.
state did not submit did not submit accusations in this case, but if we have to submit accusations at this point, because it's our contention that it should be on felony first appearance tomorrow. But if we have to submit it at this stage, we'd be submitting warrants for battery family violence in addition to 3 additional warrants for cruelty to children in the third.
Your Honor, the kid wasn't perfect. Who is talking?
Okay, so what I have before me is a battery family violence. That's all I have before me at the present time. She deserves a bond on whatever charge is before me. As such, Ms. McLeod.
Yes, Your Honor, my client is 29 years old. As we speak, she just came back from Grady because she's went in the premature labor and she's still in labor, Your Honor. I would ask the court to give her a signature bond. This was a misunderstanding between herself and her sister. I understand that the court is likely to say that she cannot have contact with her sister if the sister is not on, and I do not believe that she's on, Your Honor. But I would certainly ask for a signature bond for my client so she can get out of jail and get to the hospital to have the care that she needs right now.
Okay. If Keisha Thompson is on the line and wishes to address the court, now is your opportunity to do so. All right, does not appear so. It will be a $5,000 signature bond through pretrial level 1, 1-day anger awareness, no further contact with Keisha Thompson, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, ma'am.
That concludes my business before the court today. May I be excused?
Yes, have a good afternoon. Thank you, Ms. McLeod. I appreciate it.
Next, we have position number 6, Mason Faddis.
Good afternoon, Mr. Mason. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor. Good afternoon. Thank you.
Yes. Thank you. Mr. Mason, you've been charged in case 24 CR 000827 with simple battery family violence. Is there a history, Mr. Howard?
11 total. He was just arrested last month for harassment phone calls out of, I think, Johnson County. Before that was 01 suspended license. This was level 3.
Graham?
Thank you, Your Honor. This incident took place February 2nd, 2024. I'm sorry, let me make sure that date is correct. Yes, Your Honor, sorry about that. February 2nd, 2024, law enforcement responded to a domestic dispute at 8350 Roswell Road in Sandy Springs. Upon arrival, officers spoke with Tarnisha Mosley, who advised she had gotten into a verbal argument with her boyfriend, Thaddeus Mason, at their apartment. She explained the argument became physical when she began to walk away from Mr. Mason. He grabbed her by the hair from behind, pulled her backward, and then began to choke her. She advised that he let her go. The argument continued. The officer did observe some strands of her hair on her back, and the top of her hair was disheveled. Our office has not been in contact with Miss Mosley, and the state is recommending a signature bond through pretrial services and anger awareness course. No further contact with Tarnisha Mosley. Stay away from the incident location, 8350 Roswell Road, Sandy Springs, no alcohol, drugs, or weapons.
Mr. Cook?
Your Honor, we would certainly agree with like the signature bond at whatever level the court deems appropriate. My client can exercise any stay away or non-contact provision.
Okay, it'll be a $3,000 signature bond through pretrial level 3, 1-day anger awareness. No further contact with Tanisha Mosley. Stay away from the Roswell Road address. If necessary, he can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Mason.
Good luck, Your Honor. Thank you.
Next, we have position number 8, Mobley Joe.
Good afternoon, Judge.
Hi, Ms. Tucker. Good afternoon.
I'll be handling the end of the calendar.
Okay, very good. Good to see you.
Thanks.
Good afternoon, Mr. Mobley. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're completing by video. Do you agree to have your case heard by video?
Yes, good afternoon.
Thank you, Mr. Mobley. You've been charged in case 24 CR 000829 with 2 counts of simple battery family violence. Is there a history, Mr. Howard?
20 total on probation, possession of a Schedule 1. 2016 driving without a valid license conviction. 2016 DUI conviction. And a 09 simple battery DV conviction.
Tucker?
Yes, Judge. The state would be asking for a $1,000 good bond on each count for a total of $2,000 with no further contact with the victims April Mobley, APRYL, April, and Sanaya Mobley, SANIYIA, or YAH, excuse me, as well as to stay away from the incident location 7140 Rivertown Road in Fairburn, Georgia. An argument occurred over what to do with the children over President's Day, and this argument turned physical with this defendant pushing April and eventually grabbing both daughters' heads and banging them together. He admitted to the officer that he did get in an altercation with both daughters because they disrespected him. We did speak with the victim, April, who confirmed the events in the warrant, stated, he hit her and her sister, that this is not the first time that he's been violent to her, just the first time that law enforcement has been contacted. She does not want any contact with him, and she does not want him to return to the residence. So we will need a one-time law enforcement escort to retrieve his belongings. Additionally, you did hear he's on probation while this happened for a felony. He does have a prior simple battery family violence conviction, and I noted an FTA from 2009. So between his risk of reoffense, the risk of violence towards these victims, as well as a risk of flight, we would ask for that $2,000 total bond.
Thank you. Ms. Kim?
Yes, Your Honor, my client, Mr. Mobile, is 44 years old, and he is a proud father of actually 7 children, and he resides with all of them, Your Honor. He's a single father of 7 children and 1 grandchild. He is gainfully employed at Omni Hotel as a supervisor, and he's working there for full time, and his income is the very income that everybody is relying on right now. So it is very important for him to go back to work, keep the job, so he can support 4 minor children plus 1 grandkid. And Your Honor, and besides, although children 18 years old is still completely depending on him financially. And he completed high school successfully, and he also has a 30 credits from college for hotel hospitality. And we would like to request for signature on bond. Even with pretrial service, he does need a signature on bond, so that way he can get out of the jail and be responsible financially. Your Honor, he denies the allegation, and that place is his place. He is the one who resides there, who has his name on the house, and everybody else is just living there together. He strongly prefers to have no further violent contact, and if it has to be no further contact, it will be very difficult for children, not for him. Thank you, Your Honor.
So let me understand, who is April Mobley to Mr. Jules Mobley?
Yes, that is his daughter.
And
Both
how old-
victims are the daughters.
Okay, and how old are they?
I don't have that info. April is 25.
Okay. Sanaya, is she an adult also? Do you know, Miss
19 years
Kim?
old, Your Honor. 19 years old, but financially still relying on her father.
But they both live at the Rivertown Road address?
Yes, Your Honor.
Okay, but well, they seem as though they don't want contact, so they're gonna have to make, or he's gonna have to make arrangements in that regard, because if they don't want contact, then I'm not going to allow contact. I will allow him to get out and provide for these other children. So it'll be a $2,000 signature bond through pretrial level 2 for each offense, makes for a total of a $4,000 signature bond through pretrial level 2, 1-day anger awareness, no further contact with either April or Sanaya Mobley. He is to stay away from the Rivertown Road address as long as they are at that address. Of course, if they decide that they're going to leave that address, then he can reside there. But if they're residing there, he necessarily can't be there. As such, he can have a one-time escort to retrieve any belongings that he may have there. No drugs, alcohol, or weapons while out on bond.
Your Honor, can we have a third-party transfer for 4 minor children? They are the bigger sisters, but they don't take care of the minor children, Your Honor.
Well, if they're not taking, he won't, if he doesn't, okay. So he has other children
Yes,
that are,
8 children are living together with him. 7 of them is his own children, and 1 is a grandchild.
is either the grandchild of April or Sanaya?
April's child is a great child.
Okay, so if April doesn't want contact with them, then I assume that she doesn't want her child to have contact with him. So there's no third-party transfer necessary for that. And as far as the other children go, if they're just sisters, I mean, he can contact them directly because the stay away is from April and Sanaya.
Okay. Okay. Okay.
Okay?
Your Honor.
All right. Good luck to you, Mr. Mobley.
Next, we have position number 9, Patterson Cagril.
Good afternoon, Mr. Patterson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. You have been charged in case 24 CR 000830 with criminal trespass, willful obstruction of a law enforcement officer, and simple battery against a police officer. Is there a history, Mr. Howard?
Third arrest, got an open 2023 shoplifting, obstruction, possession of marijuana. 2022 theft by taking, trespass, entering auto. This was level 2.
Okay. Yes, Ms. Tucker.
The state would be requesting 2,000 good bond on the simple battery and 500 on the obstruction and 500 on the trespass for a total of $3,000 good bond, as well as to stay away from MARTA. This case, this defendant entered the MARTA 5-point station without paying and refused to leave. He was asked several times to leave. He resisted arrest. He refused to place his hands behind his back, and he fought aggressively in an attempt to flee. He ultimately kicked Officer Armstead in an attempt to evade arrest multiple times. And considering simple battery on law enforcement is a high and aggravated misdemeanor, and he has a previous obstruction from 2023 that's still pending, I don't believe this is a good case for a signature bond, and we would be asking for that $3,000 bond with a stay away from MARTA.
Okay, Ms. Kim?
Yes, my client, Mr. Patterson, is 19 years old, Your Honor. And I tried to reach his mother. I'm not sure if she was able to come to the bond hearing. Anyway, he is recently graduated from North Atlanta High School, May 2023. He graduated, and he has been working as a forklifter at Nissan warehouse. He drives crane, and he's been working there diligently, Your Honor. He got scared. He denies the allegation of being violent. I think he's willing to stay away from MARTA. We would like to request for a signature on bond through pretrial letter 2.
What's his? Okay. And he is living with his mother?
Yes.
Okay, for the criminal trespass, it'll be $1,000 signature bond through pretrial. For the obstruction, $1,000 signature bond through pretrial. For the simple battery, a $3,000 signature bond through pretrial, all level 2, makes for a total of a $5,000 signature bond through pretrial level 2. 1-day anger awareness.
We can't hear you. What you say?
When did you stop? 1,000 for the first 2, 3,000 for the
Can y'all
simple
hear
bat. Can you all hear me?
Yeah, I can hear you.
I hear you, Your Honor.
Yes, I can.
Okay, Mr. Howard, apparently.
Man, that's on me.
We can't hear you, Mr. Howard.
Yeah, can y'all hear me now?
Okay. So
It's real low.
Can y'all hear me now?
Barely.
Very low.
All right.
another one.
Give me that total again, please.
Okay, 1, 1, and 3 makes for a $5,000 signature bond through pretrial level 2. 1-day anger awareness, stay away from MARTA, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Patterson.
Next, we have position number 10, Mr. Rover.
That's cool.
Good afternoon, Mr. Rover. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Rover, you've been charged in case 24 CR 000831 with hit and run and following too closely. Is there a history, Mr. Howard?
I got 11 total. 2023 fade to appear. Open 2023 case out of Douglas County. Sale of marijuana. Possession of a knife or a firearm during a commission. DUI. 2 DUI arrests from 2018, 2014 disorderly conduct conviction. If you give him a pretrial, this was level 3.
Okay, Ms. Tucker?
Yes, Judge, the state would recommend a $2,000 good bond on the hit and run and a $500 good bond on the following too closely for a total of $2,500. The victim was rear-ended in this case and initially spoke to the defendant, but the defendant left the scene as soon as they heard they were calling the police to do a report. Because he initially stopped, they were able to get the information of the car owner who was called and stated that it's his daughter's boyfriend, and he confessed to him that he was involved in this accident. You did hear I have 4 prior DUI arrests. He had a 2016 that was reduced to reckless, but it was a DUI arrest initially, as well as the 2018, 2023, and a 2023 FTA. So it makes me wonder if that is why he ran in this case. We have no evidence besides the history, but I believe the FTA, as well as the charge hit and run itself, shows a high risk of fleeing, a high risk of flight. So for those reasons, we would ask for that $2,500.
Thank you. Yes, Ms. Kim. You're on mute, Ms. Kim, if you're speaking.
Yes, Mr. Rover is 30 years old and he was born in Maryland, and yet he has been here in Georgia for the last 7 years. Your Honor, he's gainfully employed at the Albert as a cook. He also has an associate degree, and Your Honor, he's engaged. He has 2 minor children, 3 months and 4 years old, that he has to take care of, financially responsible, and he denies the allegation, and he said that he stopped and then everything was supposed to be taken care of. He's expecting that the bond should be posted. We would like to request for signature on bond through pretrial level 3, Your Honor.
For the hit and run, it'll be a $1,250 good bond. For the following 2 closely, it'll be a $250 good bond. Makes for a total of a $1,500 good bond. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Mr. Rover.
Thank you.
Welcome.
Next is position number 11, DeMarcus Sims.
Yes, good afternoon, Mr. Sims. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Sims, you've been charged in case 24 CR 000812 with willful obstruction of a law enforcement officer, simple battery, and failure to report striking a fixed object. Is there a history, Mr. Howard?
I got first arrest. Jail is the recommendation.
Okay, Ms. Tucker.
Yes, we would be requesting a $2,000 surety bond on the simple battery and $500 on each other charge for a total of $3,000. The facts allege that Mr. Sims drove over a curb and hit a pole and attempted to leave the scene. When the officer tried to apprehend him, he resisted arrest and caused the officer to sustain cuts and abrasions. So that simple battery should be amended to, I suppose, a full battery or a battery against an officer. So even though this is his first arrest, considering that is that high and aggravated misdemeanor, we would not be recommending a signature bond and instead ask for that $3,000 good bond.
Yes, Your Honor. Mr. Sims is 30 years old. He was born and raised here in Georgia, Your Honor. He is gainfully employed at Burger King as a manager. He also works as an event security guard at Georgia Tech. He's also actually enrolled as a freshman at Georgia Tech. For his major is software engineering, Your Honor. He had GPA 3.3, graduated from high school. He's a very brilliant young man, smart as well. he denied the allegation and he did, we would like to request for signature on bond through jail since he is recommended. I was going to actually ask for pretrial diversion since this is his first offense. We would like you to consider that he had no offense in the past. Thank you. He does have a brain injury that he has to continuously take care of.
Okay. For the obstruction, $1,000 signature bond through pretrial. Simple battery, a $2,000 signature bond through pretrial. The failure to report, $500 signature bond through pretrial. Makes for a total of a $3,500 signature bond through pretrial level 1. 1-day anger awareness, and no drugs, alcohol, or weapons while out on bond.
Your Honor, there were actually 4 charges. So which one, I just wanted to verify that which one is actually NOD'd, so that way we don't get stuck in the jail. My client has a willful obstruction, driving hit and run, simple battery against a police officer, and failure to report.
I don't have a hit and run on my calendar.
And then my, she has a theft like shoplifting in another state card. Your Honor, because of the technology outage, there are some few things that we really have to be very careful about, like charges wise. Yes.
Like what?
So on his street card, it says theft by shoplifting.
I'm sorry, I'm not understanding.
So one of the charges are theft by shoplifting on his street card.
So so there's a theft by shoplifting. It's an erroneous theft by shoplifting.
I really think that's error in terms of it was handwritten by officer at temporary street card, and yet we also want to make sure that it is not charged. So that way he can get out of the jail, he can be released.
So he's being held on a warrant for theft by shoplifting, but you're saying it's not his name, it's not him?
No, we're just trying to make sure that's all the charges, because on his street card, it says theft by shoplifting. One of the charges are theft by shoplifting. But on the calendar, it's just these 3 charges.
Okay, well, I would have to see this warrant. I'm not sure that it's in error. He may have a shoplifting that the state would want to accuse. I
The one that
suppose.
I have does not have a theft by shoplifting. So we have 2 different versions. That's why we want to clarify for relief this hearing. What we have is a driving hit and run. So can we safely say that driving hit and run is NOD? And then theft by shoplifting is error, human error?
So, Your Honor, I was in court yesterday, and yesterday he did, and I think I submitted actually the NOD for the hit and run because it was a single vehicle accident. It sounds like what the deputy at the court is saying is on the 3 car, and I'm looking at his 3 card, and it has the willful obstruction, the driving hit and run, the simple battery against a police officer, and failure to report a striked object. I don't see a theft by shoplifting, but I do want to point out that the hit and run was NOD'd, and it was submitted to the court at the same time that the accusations were.
Okay, thank you very much.
You're very welcome.
Okay.
Well, yesterday, and thank you for bringing Mr. Pierre Thomas. We did not see Mr. Sims because we were told that he was released.
Right. Exactly.
Right.
And so we talked about that with the court today as well. And so obviously he's still in custody. And so it may be some issue with, misunderstanding of that theft by shoplifting. What I'm looking at is the 3 card, and it has the 4 charges, and 3 of them have been addressed and are on the calendar today, and 1 is in fact an NOD.
Okay, so what do we do about the theft by shoplifting?
Right,
it-
is there a warrant? I mean, what are you saying is holding him?
I'm not saying it's holding him, I'm just trying to make sure that it's not a part of,
Your Honor, I just spoke to Records, Miss Houston and Records, and he was actually cleared to go home. I don't know why he's on this full sheet. I just spoke to, Miss Houston, this is what she told me.
Okay, so,
I'm the one that brought him to court yesterday, and this is what I was told.
well, okay, I don't. Well, did he make bond? Is that why he was released?
Yeah, he had made
Yesterday?
bond. Yes, sir. Yes, sir.
Oh, okay. Well, if he's already made a bond, then I guess I don't know why he's seated in front of us.
Yeah, I believe there was a theft by shoplifting charge that was put on him by accident. It was supposed to have been with another individual, another inmate.
Okay,
They charged with his name, and it shouldn't have been with him.
okay. And the bond that he made, was that a good bond?
Yes, sir.
Okay, so if he's already made bonds, then Miss Bridgewater, any help here?
I'm confused. So if he's on the calendar today and you've just given him a bond and they're saying that he made bond, so what do we do with this case?
Your Honor, everything associated with yesterday was submitted yesterday. So I did not submit, or the state did not submit new accusations or any changed accusations in any way, shape, or form. We were just ready to argue bond because we reached out to the jail. The jail said he actually did not bond out, and he then showed up on the calendar. We never requested for him to be put on the calendar today. We're actually in that same predicament, I believe, for Jelani Horton, which is on the.
Well, let's not get ahead of ourselves. I
Okay.
can't
Yeah.
one at a time.
So let me ask this, right now on Mr. DeMarcus Sims, does this stand what we just went through with these charges?
Theoretically, if he bonded out yesterday, or if it was announced that he bonded out yesterday, then he should not have even been on the calendar today.
Exactly.
Okay, but I want to make sure that, because that young man's been still sitting here and another night in jail, so
And this is what I was told from Records. I went to Records personally myself, and they said that he was cleared to go home, his bond was paid. But he had that theft by shoplifting, which didn't belong to him.
okay, and so okay, so the theft by shoplifting, is there anything else that we need to do in regards to that so that this young man gets out?
We need NOD just to be safe.
It's not like it's a jail error. That's my interpretation.
That's exactly what it was.
Yeah.
Okay. So
think
we
it's
don't need to
really
do anything with that. They're gonna, is that what you're telling me, Norris?
Word with the correct person.
All right, good.
Okay, so again, Your Honor, as far as position number 11, DeMarcus Sims, how should I mark my calendar with him being on here today?
Okay, out of an abundance of caution, I'm going to give him an SOB through the jail so that at least they'll have some type of paperwork. So the obstruction will be $1,000 SOB through the jail. The simple battery, a $2,000 SOB through the jail. The striking a fixed object, a $500 SOB through the jail, makes for a total of a $3,500 SOB through the jail.
Okay,
And that's out of an abundance of caution so that this young man will be released.
gotcha. Thank you.
Okay, all
Okay.
right. Good luck to you, Mr. Sims. I'm sorry that that you had to sit there for another night.
Should I take off of that 1 day of anger awareness?
Yes, please.
I will.
So it's all SOB jail, correct?
It is all SOB jail.
Okay.
Your Honor, can we address the Horton case since we're in a similarly situated situation? I don't know what kept them in, but the announcement on that day was that the person had bonded out for these exact same charges that are on the
Yeah, it
calendar.
was on Saturday.
Okay. So is Horton there?
I should have asked the judge to just do 5,000 good since he was bonding out on 5,000. Just to, you know, it would have made sense.
We have Mr. Robert Wright.
So I guess we don't have Horton.
Be on the add-on calendar.
Okay, I'm sorry. Tell me what the issue is with Mr. Horton now.
Mr. Horton was on the calendar on Saturday, I believe, and according to the state's notes, the announcement was made in court that the person had bonded out. Somehow they've showed up on a add-on calendar here today, and so I think that that person is maybe a different circumstance, but similarly situated as the previous defendant.
Okay. Had Mr. Horton received a bond previously?
No. So Saturday, it was said that when I email records, it was stated that he hadn't bonded out, but his attorney kept saying that he did. He talked to his mother and the people from the bonding company. So they just left it at the 5,000 that it was at. We just put bonded out on the paperwork. So she didn't give him another bond because it was said that he had bonded out.
Okay, so does he have a bond or doesn't he?
5,000 was the bond that he came in with.
Okay, so let me go ahead and hear this matter. So 5,000 good is what he came in with.
Correct.
Okay, good afternoon, Mr. Horton. I'm Judge Eric Morrow. This is the State Court Expedited
I
Accusation.
don't think that's Horton, Judge.
Oh,
Is it? Because he's a 17-year-old. I do know that.
He's at Union City.
Okay.
so before me is Jelani Horton. Is that yes or no?
No.
No. Okay, so who do I have here then?
Mr. Robert Wright.
He's the add-on on number 3.
Okay,
I don't have a history for him. I guess the state has it.
Yes, we received his warrant at about 1:40 today. So I drafted up an accusation real quick. You don't have his history, you just said?
Correct. I knew nothing about it.
Okay. I believe I have a history. If you'll give me one moment.
okay, you get that while I address Mr. Wright. Good afternoon, Mr. Wright. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Mr. Wright. Let's see. You have been charged in case 24 CR 0000835 with reckless conduct from December 28th of 2023 is what I have. Miss Tucker, do you have the history now?
Yes, Judge, it's 23 cycles. And I'm going to start with the most recent 2023 probation violation is his most recent. Probation violation 2023. 2023 receipt of firearm during felony. Probation violation. An aggravated assault and battery family violence conviction out of Cobb County from 2018. Many probation violations, and I will just stop there. We would ask in this case for at least a $5,000 good bond. This is a case involving a gun in which a gun was shot into the air, which of course places everybody in the surrounding area at risk of injury. There was an incident, so this was, instigated by an argument with the victim, who was the defendant's ex-girlfriend. So it is kind of a domestic violence situation. which you heard he has that prior domestic violence conviction and ag assault. And this involves a gun. It's a very serious high public safety case. So we'd be asking for at least a $5,000 good bond. Stay away from 2705 Jasmine Parkway in Alpharetta, and to have no further contact with Mandisa, Mandisa, Pace, Pace. That's the ex-girlfriend whose apartment this gun was shot at.
Ms. Kim?
Yes, Your Honor. Mr. Wright is 33 years old. He was born and raised here in Georgia, Your Honor, and the battered family violence history is from 2018, almost 6 years ago. It is relatively remote. And Your Honor, he is gainfully employed at Kroger and also security business. He does have a small security business as well. He graduated from high school and he is attending Clark Atlanta University to pursue his associate degree. He has a surgery actually scheduled for next week, and he has been in the jail ever since from February 6, 2024, Your Honor. He was arrested for seatbelt and cell phone at College Park, February 6, 2024. He was transferred to Fulton County on February 7, 2024. So it has been almost 2 weeks. He didn't have his first appearance for these issues, which happened December 28, 2023. So we believe this is a Riverside issue. He has served the time, more than time served, you know. We would like to request for signature on bond through jail.
Ms. Tucker?
So I'm about to look into when he was booked in. If you'll give me just one moment, because this case came to us so late in the game. I do believe I see Miss Mandisa Pace. We haven't had a chance to speak with her, I don't believe. But if you would like to sound for her while I'm looking into the when he was booked in.
Okay, Ms. Pace, see that you're on the line. If you would like to address the court, now is your opportunity. You, of course, do not have to address the court, but if you would like to, you'll have to activate your camera, unmute yourself, and I'll have to swear you in. Yes, ma'am. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can place your hand down. What would you like to tell the court?
Honestly, Robert has been following what the detective told him, and he's been staying away. He's been cordial. He hasn't been contacting me. And ever since that day, he's been leaving me alone.
Okay, and that's what you want?
Yeah, I haven't had an issue with him since.
Okay, and what was the issue at the time?
The issue was an argument that we were having, a personal disagreement, and he wanted to come into my home, and I wouldn't let him in my home, and that was it. He was banging on the door, and then I did hear a shot go off, and then I was like, I told the detective, I don't know if that was him that shot the gun, but I know it was banging at the door, and that was it. And the detectives was asking me all types of questions. And I was just like, I just want to be left alone. And he's been leaving me alone ever since that day.
Okay, thank you, Ms. Pace. We appreciate you
You're
being here this
welcome.
afternoon. Ms. Tucker?
Yes, Judge. I'm having trouble opening Odyssey. I know we're supposed to have at least a view-only access to it at this point, but I am unable to check on when he got in to the jail.
February 8, 2024. February 8, 2024, officer verified actual record, Your Honor, in the jail.
And he was booked on this case?
Yes,
I believe so.
yes, he was at College Park first for another charges. And then he was transferred for this particular one on February 8th, 2020.
Okay, I do say, so he was arrested the 7th,
Yeah,
city of South Fulton, for possession of firearm by felon.
So has he seen anyone in regards to that charge?
yes, February 8th. Those were all at the College Park before he came here.
And why was he brought here for this charge?
Yes, reckless conduct.
So on December 8th, or excuse me, February 8th, he was brought. And I suppose I'm confused why this, I'm just as confused as you, Judge, why this case, oh wait, this case was with felony, I believe, because that's who sent it to us at 1:40 today, was felony first appearance or whatever their team is. They sent it to us. So I'm not sure. It sounds like it probably is a Riverside issue. I really can't confirm or deny what happened in this case.
Well, he obviously doesn't have a bond, so something went wrong.
No, he had a bond, Your Honor. He also paid the bond.
Well, that's even more confusing to me then, right?
Yeah.
So if he has a bond, why is he still here? And what do I do with it?
That's
All
what.
right, so out of an abundance of caution again, it's going to be a $10,000 signature bond through the jail. Surrender all weapons, no drugs, alcohol, or weapons while out on bond. Okay. Good luck to you, Mr. Wright.
We could do position number.
We have a waiver of appearance case, Your Honor.
Okay, I think we have two, right? Do you want to go ahead and do those?
Position number 12.
Yes, Ricky Williams.
Okay. Let's see. Mr. Williams is charged in case 24 CR 0000832, a criminal trespass. Their history, Mr. Howard.
55 total. Last arrest was last month. Public indecency and obstruction. Possession of drug-related objects. 2023 failure to appear. He had a 2023 trespass conviction. 2023 trespass obstruction. Another 2023 trespass. 2023 trespass, public indecency, NOLO. I stopped there. I didn't even go past 2023.
Okay, Ms. Tucker.
Yes, Judge, we would be asking for $1,000 good bond based on the history. I don't believe he is a good candidate for a signature bond. Additionally, the facts of this case are that he was found in MARTA and he has a permanent ban for MARTA issued in October 2021. So he's had time. He knows he's not supposed to be there. You heard all those criminal trespasses. So we'd ask for that $1,000 good bond.
Ms. Kim.
Yes, my client, Mr. Williams, is 30 years old. He was born in Mississippi, and he's residentially challenged. So our social worker who was here, Mr. Jamel Harris, is gone to visit with him for BHET to make sure he does not have any competency issues. And other than that, he graduated from high school. He does not reside here in Georgia. He doesn't have a permanent residency yet. So that's about it, Your Honor.
It's going to be a $500 good bond, social worker visit, and no drugs, alcohol, weapons while out on bond, and stay away from MARTA.
Thank you. And then
All right, the other waiver is position
two on that.
2 on the add-on.
Yeah.
Okay, and this is Horace Roan,
Yes, Your Honor.
case 24 CR 0000834, criminal trespass and willful obstruction. See the history, Mr. Howard? You with me, Mr. Howard?
My bad. 16 total, 2014 trespass conviction, 2014 shoplifting public peace conviction, 2013 breach of peace, 2013 failure to leave property conviction, 2012 trespass conviction, 2012 disorderly intoxication conviction, another trespass conviction from 2012, that was not his year, 2012 disorderly conduct conviction, and another 2012 trespass conviction. Now, these are
All
out of
right.
state.
Ms. Tucker?
Yes, Judge. The state would recommend $1,000 signature bond through pretrial. Despite having a significant history, it does appear that it's been a good amount of time, about 10 years. The facts allege that he refused to leave the 191 Peachtree Street building despite having received criminal trespass warning in the past for the same location. And he did threaten the officer and resist arrest, but it's my understanding he didn't hurt the officer. So we would be amenable to $1,000 signature bond through pretrial in this case.
Any objections, Ms. Kim?
I believe Ms. Drew has more to say about him.
Okay.
Hi, Judge Morrow. How are you?
Afternoon. I'm doing well.
Good
I hope you
afternoon.
also.
Yes, sir. So Ashley Hebel, who is a colleague of mine, went to go visit to interview him today. After about the third question, started getting a little aggressive and hollering. And so we've actually sent his name over to Grady, submitted Grady within the jail working group. We believe he needs a higher level of care than Pat can offer.
Okay.
Competency issue.
Right, okay. So let's see, Miss Kim, if you can prepare an order for me. And I guess given that, it will be a $500 good bond per charge, which makes it $1,000 good bond. Mental health evaluation will get me that order, and no drugs, alcohol, or weapons while out on bond. Thank you, Ms. Umberg. I appreciate your input.
Yes, sir.
Okay. So what happened to position number 4, Cornelius Hunter?
I believe he bonded out, Your Honor. Number 4.
Yeah, he was released. He's released.
Okay, so does that conclude the calendar?
I believe so.
But
Okay. Okay.
Position 1 on the add-on. If anything, we can resend tomorrow.
No objection.
Oh. Right. What, where is Mr. Horton?
Union City.
He's at Union City.
Wow.
Okay.
He was supposed to be released yesterday, so if possible, I think we can just kind of get him released today. Wasn't he here yesterday?
This is 17.
17 years old?
Saturday.
Saturday, yeah, he was supposed to be released on Saturday.
Well, what happened on Monday?
Does it-
I mean, I was here on Monday. So,
Does anybody know what
Yeah.
happened to Mr. Holton on Monday? No, nobody could find him.
Yeah.
okay, so there's gonna be an issue with this, I guess, tomorrow then. So Yeah, and there might be an issue for today, but if we don't have him, there's nothing I can really do. I'll request him for tomorrow. And I also, Ms. Kim.
Yes, ma'am, sir. Yes, Your Honor.
We're also going to, have you been in touch with a parent?
He was not my client, so I did not do.
Okay, so we'll need to get in touch with the parent also. So maybe if that'll give you all enough time to have a parent if possible, or a guardian here for him tomorrow also.
Paul was the his attorney on Saturday. You might want to talk to him. Bartel. Yeah.
Got it. We'll do that.
Okay, thank you.
Thank you.
Miss Bridgewater,
Yes, sir.
whenever you're ready, I guess.
Okay, once again, the reset date for the SAP calendar is March the 5th. Position number 1 is reset further notice with a $2,000 SOB through the jail. Position 2 is reset further notice with a $2,000 SOB through pretrial. Position 3, reset further notice with a $2,000 SOB through pretrial. Position 4 is reset further notice as the defendant has been released. Position 5 is reset further notice with a $2,000 SOB through the jail. Position 6, reset further notice with a $3,000 SOB through pretrial. Position 7, reset further notice with a $5,000 SOB through pretrial. Position 8, reset further notice with a total $4,000 SOB through pretrial. 9 is reset further notice with a total $5,000 SOB through pretrial. Position 10 is going to the SAP calendar with a total $1,500 good bond. 11, reset further notice with a total $3,500 SOB through the jail. Position 12 is going to the SAP calendar with a $500 good bond. Position number 1 on the add-on calendar is going to be reset till tomorrow. Position 2 on the add-on calendar is going to the SAP calendar with a total $1,000 good bond. And position 3 on the add-on calendar is reset further notice with a $10,000 SOB through the jail. Are there any questions, comments, or otherwise?
Nothing further from defense.
Okay, if not, thank you all. Have a good rest of your day. We'll see you next time.
Thank you.
Goodbye.
Bye-bye.
Okay, but I probably ought to do it. You want to give me your phone?
Okay.
Okay.
Yeah, mine is kind of